Joel Reese on behalf of the plaintiff.
And Your Honor, for the defendant, Sesto, the shell entity, Tim Durst, and also Christopher Hunt.
And there's a possibility, as I understand it, there may be another lawyer who may be joining us.
Yes, Your Honor. Joe Master Giovanni, he said that he tried to log on but was having issues. So we'll proceed without him, and if he's able to join, if it won't.
Could you just state and spell his name for the court reporter just in case he ends up joining us?
Yes, Your Honor. Joseph, and his last name is Mastro Giovanni. It's spelled MASTROGIOVANNI. Well, thank you, Your Honor. If it's okay, I think it would be helpful to give you a brief explanation of the issue that we're having with the discovery issue. And then, like I said, I think that will largely inform then the discussion on the trial setting. As you'll recall, in the Whiting lawsuit, Your Honor entered an agreed protective order that governed documents that were designated as confidential or highly confidential and gave the parties a mechanism for filing those documents under seal. That protective order, of course, included standard language that you can't use those documents for any other purpose, including other litigation. In that other action, as you know, Your Honor, Shell produced thousands of pages of documents. They also presented witnesses for multiple days of deposition testimony, and those witnesses were defended by the lawyers that have appeared for Shell in this case. Your Honor, we believe in that case, in the Whiting lawsuit, that Shell abused the protective order by over-designation. But what we did at the time, because we wanted to avoid burdening you with a motion to de-designate, was we reached limited agreements so that way we could just move the case forward. For example, allow our clients to see the documents, allow witnesses to see the documents. Your Honor, Mr. Master Giovanni just joined.
Great.
So, as I mentioned, Your Honor, so instead of filing a motion to de-designate, we tried to just move the case along by reaching agreements that address the immediate need. So why does all this matter now that we're in the Shell case? Well, Shell's position is we as the plaintiff should not be allowed to use any documents or any deposition testimony that was obtained in the Whiting lawsuit because the protective order in the Whiting lawsuit says you can't use it for other litigation. And that includes the documents that Shell produced, and that includes the deposition testimony that Shell produced. Quite frankly, Your Honor, we see it as a way that Shell's trying to throw up roadblocks to just slow down this case. And we're left with very few options. As you know, Whiting filed for bankruptcy, and the Whiting lawsuit is stayed. We cannot go into that lawsuit and file a motion to modify that protective order. We cannot consolidate this case with that other lawsuit. We cannot file a motion to de-designate the documents that we believe Shell improperly designated confidential. So if Shell were to get their way, we would have to spend the next couple of months getting Shell to reproduce the thousands and thousands of pages of documents they've already given to us once. And we'd have to retake multiple days of deposition testimony when these lawyers were there present and defended those witnesses. Or, in our minds, a more practical solution would be to enter a protective order in this case that allows for us to use that discovery in that case, of course, subject to, other evidentiary objections or whatever, but it allows us to move this case forward, and those documents or deposition testimony would be afforded the same protection in this case as they are in the Whiting lawsuit, Your Honor. Unfortunately, Shell does not want to do that.
Mr. Durst, that position doesn't seem to make a lot of sense, so there may be more to it than it's being said. So, Mr. Durst, what is Shell's position on this?
Yes, Your Honor. The position may not seem to make sense because it's not the position that we're taking.
Okay.
So Your Honor, the narrative that JMEX is laying out is incomplete. So the JMEX Whiting litigation proceeded for 2 years or something on that order of magnitude. with Shell involved as a third party. The court will recall we've been there for three motions or something on that order. We had 4 of our witnesses that were deposed as third parties out of, I don't know what the total number is, approaching 20. We don't know because we don't have access to the rest of the record in the Whiting case. We produced a couple of thousand pages of documents, or a couple of thousand documents, as Mr. Garris mentioned. But from what we can tell, there were well over 100,000 pages of documents produced in that Whiting litigation, 40 boxes, I think. And we know that only because we've seen documents with document controller Bates numbers on them that exceed 100,000. We do not have access to that record. So the factual record in the Whiting JMAX litigation was developed under that protective order without us fully participating. The piece of this that Ms. Chigurhs mischaracterizes in terms of our position, and I will tell you, Judge, she and I have never had a conversation about this, so I'm not quite sure where she gets our view on our position. But there, of course, will be some things from that other litigation that can move over here, right? So, I mean, just under the Texas rules of civil procedure, some of that deposition testimony may come. But we've never deposed the JMAX witnesses. We've never seen their transcripts. We weren't at their deposition. Same on the Whiting witnesses. We don't know what JMAX produced there. We don't know what Whiting produced there. And so the starting point is that whole case developed with us having maybe a 10% view of what was going on. And that was because it was developed under a protective order that JMAX and Whiting put in place. And Your Honor, with your permission, I will share my, if I'm allowed, can I share my screen with you, Judge?
Yeah, I need to, okay.
Ready?
You should be able to now.
Okay, I'll give it a shot. Let's see. And here we go. Okay. Your Honor, can you see the PowerPoint that we have up of the protective order?
Yes.
Okay.
I can see it.
So this is the protective order that you signed, Judge, on the 26th day of September in 2018. The Whiting and JMAX parties agreed to the entry of this order. Shell was not a party, was not a part of it. This protective order actually goes beyond, in my experience, the sort of thou shalt not use this for any other purpose. It expressly says can be used in any other litigation, any other legal action or matters, and that material cannot be used outside of that case. The problem that we have, and the reason this hearing arose, Your Honor, is because JMAX, even though we called this language to their attention, Your Honor, they filed a motion for summary judgment against Stusco, against Shell, in this case, using discovery entirely from that other case, in direct violation of your order. And it wasn't an accident, Your Honor. They asked us in advance, and we said, just be aware, we don't have any opposition to you filing an overlinked appendix, but you can't violate the Whiting protective order. And that Whiting protective order makes a lot of sense, Judge, because we're dealing not only with JMAX's information, we're dealing with Whiting's information in that other case. Whiting, of course, is not here. Whiting's in bankruptcy. And there's a lot of information in that other case that is Whiting's confidential information. In fact, from what I can gather, the bulk of it there that's marked confidential is the Whiting information. So, Your Honor, the notion that there is a factual record there fully developed that we participated in is inaccurate. We participated in some small ways that the court is aware of, but not completely. That record, portions of that record may well move over to this case, Judge, and we're willing to have a conversation with JMAX about which pieces make sense. But it's also not fair, Your Honor, just to dump that entire record into this case, because it is a it's a 2-year factual record that was developed without us participating in it. And I'm concerned about the JMAX approach here, Your Honor, as demonstrated by the fact that they tried to file a motion for a motion for summary judgment. It not only violated this protective order, but it purported to use against Shell a whole bunch of information that we've never seen before. Deposition transcripts that we've never seen before, documents we've never seen before. And so, Your Honor, I think the issue here, and they do, I agree with Mr. Garris, they do kind of meld into the scheduling order. There is no motion that is set for this hearing. So JMX didn't make any request for relief coming into this hearing. What I suggest the path forward is that we have a normal conference process. JMX brought to you the scheduling order dispute without even talking to us first. So I suggest, Your Honor, what we do is we step back, we engage in a normal discussion about protective order, about scheduling order, and about which pieces of the JMX Whiting factual record can fairly be used and brought over into this case. And that seems to me to be the most logical matter-of-fact approach. And I'm hopeful that we can agree on large parts of that. I don't know if we're going to be able to agree on the pace that this case moves, but that is something that we certainly can crystallize into for Your Honor's consideration at a future hearing.
Your Honor, if I could just briefly respond.
Yeah, and can I respond first, Ms. Shigaris?
Sure, go ahead.
Mr. Durst just said that we didn't approach them about a scheduling order, Your Honor. And I first talked to them and it started this process on April 1st in an email to Mr. Durst. And so we've tried, but the problem, what happens, Your Honor, is every time this case trying to get started, it gets delayed. And so I started that on April 1st, and we can't get anywhere with an agreement. And so what happens is we just wanted to have a normal discussion about a scheduling order and that process. And with regard to these documents, Ms. Shigaris can respond. But with regard to these documents, we have one cause of action against Shell, Your Honor, a breach of contract. And it's a contract between us and Shell, okay? And either that contract's ambiguous and you determine intent and you don't have a summary judgment, or it means exactly what we say it is, and there's nothing wrong with the summary judgment on a contract between us and Shell. That's
Mr. Reese, let me just say something here, which is, during the course of the previous lawsuit, I asked on numerous occasions, hey, why isn't Shell a party here? This seems to be really, I don't know if I said this, but I know I thought it. This seems to be really just a breach of contract case, fundamentally between JMX and Shell, with this Whiting, the overlay of what Whiting had done to cause that. But fundamentally, it was a breach of contract case. And you guys never added Shell for whatever reason to that lawsuit. And so the reason this is delayed, I think, largely is because you guys never added Shell to that original lawsuit. And so I know kind of where you're going with this is a simple lawsuit and a breach of contract. And but if you're going to bring in information and discovery from that previous lawsuit where Shell was not a party, even though you knew that Shell could have been added, I think that's kind of a problem of your own making.
Yeah, and I think we have two issues here, Your Honor. One is evidentiary issues, and what they're raising is an evidentiary issue that we didn't have the opportunity to cross-examine the witnesses. That's a separate issue, and it should be put in a different bucket. And there's another issue with regard to Whiting's documents. Okay, take that in a separate Whiting is not here. Whiting should have an opportunity with regard to their documents. We will just send a subpoena to Whiting in this case. The automatic stay does not prohibit a subpoena. So all we're asking is for everything else that's left. And those two issues, when you take them out, the core of what we're fighting about are, for example, Shell's own witnesses. And if Shell wants to take their witnesses in this case, that's fine. But there's no reason why Shell's witnesses should not, Whiting's never designated their depositions, Shell's witness depositions, as confidential. There's no reason those depositions can't be used in this case, or the documents that we produced, or the documents that Shell produced.
My initial thought on this, and this is not a ruling, but my initial thought is that for Shell depositions of Shell witnesses, that those would come over, and the Shell documents, any documents requested from Shell would come over to this case, and then Shell would be given some chance to object to that, or object to a document, or object to a deposition, or ask for additional. But kind of the initial universe in this case would include anything that Shell directly participated in. And then for the JMEX, I'm sorry, for the Whiting witnesses or discovery, I think your inclination, as you said, about subpoenas, that would be the appropriate way to do this and not try to use documents that were obtained because Shell didn't have an opportunity to participate in that. And in this case, Whiting has had an opportunity to object to them being used in this case. For Whiting's witnesses, or for non-Shell witnesses, I shouldn't say just Whiting's, but any witness that Shell was not involved with, I think they should be able to object and request a redeposition on anything that they didn't get an opportunity to participate in the previous case. That's kind of my initial inclination here. What are your thoughts, Mr. Durst?
Your Honor, I think that's very close to where I think this should land as well. And I think the court's comments and guidance on that, understanding it's not a ruling on, but that will be useful for us to sit down and have a discussion with JMEX to work through what happens with the protective order issues. And that does segue into the scheduling order discussion as well, which Mr. Reese and I have swapped proposals for scheduling order, but we've not had an opportunity to talk. I did talk to Mr. Mastrogiovanni. I don't know if he's still on here, but it was after this matter was brought to the court. It lasted about 5 minutes, and we didn't make any progress in that, but hopefully we can. It's really going to be around, Your Honor. I think the scheduling order issue is really going to be around I anticipate it will be the trial date issue, and then the parties we should be able to back into the other dates. And our view is that, Your Honor, we need sort of close to a typical level 3 scheduling order here. Some of the discovery is done, but we're going to need to take discovery of JMEX, and we're going to need to take some discovery of Whiting. And so we were working around sort of the court's guidance that you put out there in terms of what you expect to see in level 3 cases, and using that as a starting point. And we have some room to move and compromise on that. We just need to have that conversation with them.
And Your Honor, if I may, the problem, and I think the delay that Mr. Reese was alluding to, is we have on 2 separate occasions over the last month sent proposed schedules to Mr. Durst. My understanding that Mr. Mastrogiovanni and Mr. Durst have talked on a couple of occasions and have not been able to reach. If we can get a trial date, I have no doubt that then the parties can reach an agreement on the others. Both parties agree that the case should be tried in November. The difference is we believe the case should be tried November 2020, and they believe the case should be tried in November 2021. And I don't think that we're going to be able to reach an agreement on that issue. So we need the court's help on just setting a trial date, and then I do think we can work through the rest of the deadlines.
I think November 2020 is way too early. I do think November 2021 is also too late. So somewhere between there. What day was this case filed?
It was filed in February, Your Honor. We did delay filing it based on the requests of Shell because we were trying to resolve it, but it was ultimately filed in February.
What about maybe next May, like mid-May, maybe? Are y'all there?
It's obviously
looks
later.
Like you all look like you froze, and I'm like, are you still there? Or
Yeah.
We could request earlier that spring if we're going to go into 2021, like a February or March trial date. I do agree, and we have never indicated otherwise, that Shell will need to take discovery in this case, including of our client and Whiting witnesses. We will not have to take a lot of discovery because most of what we need on a breach of contract case we have. So it will be very limited, and I think we can complete discovery in a couple months. So I would push for something at least earlier in 2021, if possible, Your Honor.
So Your Honor, the 18 months that is the target that you mentioned in your courtroom procedures would put that trial set in August. May May might be workable for us. I would have thought that we might try to land in June. And let me tell you, Judge, why I think that. There is going to be some whiting discovery that has to go forward. And I anticipate that not being smooth, given the fact that they're in the bankruptcy. As you saw, if you may have noticed in some of the papers we submitted for this hearing, JMX is trying to get the stay lifted in the bankruptcy. So there's going to be this collateral litigation going on in the bankruptcy court related to whiting over these same issues. That's going to take a little bit of time to settle out. My bankruptcy counsel tells me, though, Your Honor, that bankruptcy is expected to move relatively quickly as bankruptcies go, and that in 90 or 100 days, they may emerge if Whiting's plan gets approved. And so our thinking was, in all likelihood, it's going to be difficult to make progress on those Whiting discovery issues in the next 90 days. And so what we did in thinking about the schedule was kind of build in a little buffer there. With things beginning maybe after the dust settles with respect to Whiting, and that could lead in a manageable way to a June or May 2021 trial date.
And if I may respond, Your Honor, I actually sit on the unsecured creditors committee in the Whiting bankruptcy, and so I can't disclose everything that's been said in that, but I do know that the bankruptcy will not in any way be done in 100 days. So, and from our perspective, nothing in the automatic stay prohibits the discovery. Mr. Barnett, Barry Barnett and I got along fine. I think we had very, very few discovery hearings, if any. And I intend to request the documents that he's already produced from him, and then we can take some depositions. I don't think that we'll have a problem in that regard. So at least with regard to that trial date. But let me bring up one very important point, and that is that we've requested to lift the automatic stay to have, Your Honor, you decide the proof of claim. And so we have to determine the liability and amount of the proof of claim. And so what we've requested is that be done by you through a bench trial. And then that decision goes back into the Whiting bankruptcy and is determined. We're in a certain class. We're either going to be in class 4 or class 5, but that will determine the amount that we're entitled to in either class 4 or class 5, depending on where we ultimately land. But that will not impact the case against Shell. At best, we can go forward with our case against Shell. Whatever we get out of the Whiting bankruptcy will not fully compensate us for damages, and we will, at best, they may get a credit in this case. And so what we've worked out is that's what we plan to do. Now the court may.
Let me ask this, because I don't think I've ever done that before. So I would basically just try on a bench trial, just the issue of liability in the other case, the Whiting case, and damages, I guess. Would that need to occur before the Shell case went to trial or after the Shell case goes to trial, or how does that work exactly?
It doesn't matter. It doesn't matter because what that is used just in connection with the bankruptcy. So it will not matter whether you try it before or after, but in all likelihood, because of the way the bankruptcy will want to move quickly, it will happen, particularly if we're talking about May of 21, it'll happen long before that. And so if the bankruptcy court allows, they'll either allow you to try it or allow us to lift the automatic stay to try it here, or the bankruptcy court will say no, they haven't made that decision yet, and the bankruptcy court will make the proof of claim decision. So one of the two will happen. We'll know that probably we'll know it in May. I don't know exactly if we'll know it May 6th. There's some hearings on May 6th, and there's some hearings later on May 26th. And so we'll probably know it sometime in May, and then we'll come back. But the trial will be relatively quick. It has to be a bench trial because by participating in the bankruptcy, we waive the right to a jury trial.
So just so it's clear that doesn't necessarily impact when we do the trial in this case.
It does not.
That's right, Your Honor. One of the things
it doesn't necessarily, Your Honor. It doesn't necessarily, but as the court can tell, there's a lot going on with Whiting, and so I'm just anticipating that the process of doing what we need to do with Whiting is going to take a little longer than it might otherwise. But again, we're not seeking anything sort of outside the norm in terms of the trial date here.
So why don't you guys get your calendars? Let's look at May 18th, May 25th, or June 1st. And how long do you think this would take to try?
This is also a bench trial, Your Honor. I think we'll get it done in a week.
In a week, okay.
So, Your Honor, oh, I've got the wrong. I was in the wrong year. Hold on. I was looking at the other setting that I have next spring. Yeah. The week of May 31, is that the week that you're asking, or the June? Which?
These our trials start on Tuesday, so
Right.
May 18th, May 25th, or June 1st. It's kind of what I'm looking at.
Right. June 1 is the day after Memorial Day, I think, next year. Right. That's what we're looking at.
The only problem with June 1st, Your Honor, that's Ms. Shigaris' birthday.
What a good partner. He knows your birthday. That's impressive.
It must be on his calendar, but what a great present to try a case in your court, Your Honor. Any of those dates work on our calendar.
Yes, June 1 would be our preference there, Your Honor. June 8th would be even better. Get it a week off of Mr. Garris's birthday and off.
Do you guys want to do June 8th instead?
We're fine the 18th, the 25th of May, June 1st, or June 8th, Your Honor. Any one of which is.
And let me just say one thing. This is from a scheduling standpoint, it's something we just to kind of put in the back of your mind. The way I typically handle these cases, or typically handle cases, not these cases, cases in general, is I'll try the jury cases first and then the non-jury. So even if you're an older case, the non-juries come behind the juries. The two ways to get around that, which might be an issue in this case, is to do a special setting, which is probably premature in this case, or to set this on a non-jury week, and then you'd have a much better chance of going. The caveat to that is we don't know what the non-jury weeks are next year. We won't know until probably November or December of this year. And so what we could do is just go ahead and set it, and either especially set it if you guys feel that this is actually going to go to trial. Obviously you haven't been to mediation or anything like that, so I think it's a little premature to especially set it. Or we could move it to a non-jury weeks once we find out when those are.
That approach would be fine with us, Your Honor, to set it for June 8th and then reevaluate it when the court has information about its non-jury weeks. Or as the case proceeds, consider a special setting.
That's fine with us, Your Honor.
So, Rhonda, we're going to go ahead and set this for June 8th next year. And what do you want to do about the discovery issues? Do you want to just agree to what I said, or do you want to, obviously I'm not going to order that without an agreement because there's no motion pending, but.
Your Honor, if I could make a suggestion, given that we have a trial date now, that should open the door for us to get agreement on the scheduling order. Let us do that, and in the context of that, come to some agreement on the cross use of discovery. Try to come to some agreement on the cross use of discovery and the protective order provisions that would apply here, and then circle back.
What do y'all think?
I'd like an agreement at least on the two issues that sounded like we were in agreement on, so we can narrow the things that we still have to work through. That being that the deposition testimony of the Shell representatives or witnesses and the documents produced by Shell, that those can be used in this case, subject to whatever other evidentiary issues there would be. Trying to clear the things that are still on the table for us to have to work through.
Your Honor, I think we need to look more closely at that. I think that will work, but we need to make sure, for instance, that there is not Whiting confidential information in there that we're using in a way that's inconsistent with their expectations and the protective order there. So I really think it would be it'd be premature to make a broad rule like that at this time without us talking about it. If we want to set a report back to you in 2 weeks on these issues and see if we can get an agreement. If not,
What if we did this, Mr. Durst? What if we said all of that, the discovery that you guys participated in, the depositions and the documents you produce will be used in this case unless unless Shell files a objection to those documents or depositions with specificity, like, hey, we object to these following pages, or the depositions or these documents, within 21 days, then they would be considered part of this court record. Would that give you enough time, do you think, and would that process work?
And
Mr. Hunt, feel free to step in here, because you'll probably be doing a lot of this work. So
you will be, and Your Honor, I know that things that we produced were involved whiting, I feel like, Your Honor, that is we may be able to get there, and if we have time to talk about this, we may be able to get Whiting's agreement on those pieces. But I think I would be remiss to agree to that without diving a little deeper into the information that we're talking about moving over. So remember, we responded to a subpoena from Whiting, and we responded to a subpoena from JMAX, and then the depositions. I suspect the depositions, as an evidentiary matter, as Mr. Reese pointed out, are probably going to be in play in the case, just under the rules. We just got to fix the protective order issues, Your Honor. So there's no motion pending with the court at this point. I would suggest that we do need a little bit. I hear the court's inclinations, and that will inform the way we approach this discussion. But I think it would be premature to interrupt.
Why don't we do this then? Let's go ahead and reset this for 2 weeks. I'm going to strongly encourage that JMAX go ahead and file some motions that I can rule on, so that we can get this thing off of dead center. Rhonda, go ahead and set this for 2 weeks from today, assuming that there's no holidays. That I'm not. Every day seems the same right now, so I'll make sure there's no holiday in 2 weeks.
On the 11th.
I don't see any holidays, no. So let's go ahead and set that for 10:30, 2 weeks from now. Anything that needs to be set by you guys involving this issue can be set. Is the summary judgment set currently in this case?
It's not set, Your Honor.
Yeah, don't set that until this stuff gets resolved. So
Yes,
I just realized I have another hearing I got to get to. Anything else we need to chat about?
Yes, Your Honor. We have things that are on file that are not sealed, that are under a protective order that was filed in violation of the Whiting protective order and is sitting there on public record. And so they need to be JMAX needs to fix that problem, which means they need to be taken off the docket. They need to be unfiled.
And Your Honor, we did send a letter. We filed the motion for summary judgment under seal. I talked with Rosemary in the clerk's office. I understand that the clerks are getting help from other clerks who don't normally work in your court. It was, as Rosemary explained to me, a clerk mistake. The clerk accepted the filing and didn't file it under seal. They wouldn't correct it because there's not a protective order in this case. So I sent a letter to Your Honor asking, I know Mr. Durst wants me to file a motion to unfile the document, but there's no such thing. And I know Your Honor is precluded from taking something off of the docket once it's been accepted, but we're open to suggestions. If you can order the court clerk to seal it based on the Whiting protective, if you want me to file a motion for temporary sealing order, however Your Honor wants to handle it, we will do that. But that was not something that JMAX did. We filed it under seal. It was unfortunately a clerk mistake.
Your Honor, they filed under seal without there being a protective order in place. So it wasn't really a filing under seal. Respectfully, I think what needs to happen is the clerk rejected about half of their filings. The clerk's office rejected about half their filings and accepted the other half, but filed them publicly. So probably what should have happened, Your Honor.
Why don't we do this, guys? Why don't we go ahead and have same thing in 2 weeks? If Ms. go ahead and file whatever motions you need to file, Mr. Durst, Ms. Shigaris, and go ahead and notice it. We'll set it at the same time as this other hearing. And Ms. Shigaris, if you can get this fixed with the clerk's office without the necessity of a motion, let's go ahead and do that. But if that can't be done, then Mr. Durst, you go ahead and file whatever you need to file, and we'll set it at the same time. And anything that that's going to be set for that date needs to be filed by this Friday.
Yes, Your Honor.
Okay. Anything else, guys?
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. I am stopping stream.